Hello, everybody. How's it going? This is immigration attorney Moumita. I'm coming to you live to talk to you about immigration and to see the questions that you may have on your mind today. Thank you so much for joining me. My name is Moumita Rahman. I'm an immigration attorney. I have been practicing immigration law for the past 15 years, 14 years, and it is my pleasure to do the work that I do. Give me 1 second while I fix this light. Okay, there we go. It's fixed right now. So give me just 1 second. All right, guys, I'm back. Hello, everybody. Thank you so much for joining me. Nice to see all of you. I hope everybody is having a great day. I hope everybody had a great weekend. We are here to talk about immigration and to see the sorts of questions that you may have on your mind. What are the things that you are worried about in your immigration case? What are the problems that you are going through right now as an undocumented immigrant? I would love to know, and I would love to be able to help give you some sort of insight over your possibilities in immigration. I would love to be able to give you some sort of help that I can. And if anybody wants to reach out to us for a case evaluation, our telephone number is 212-248-7907. Nick, thank you so much for the heart puff. Eshwar, thank you for the follow. Thank you so much. Let's talk about it. Moni, you're saying that my case is so complicated. I feel like there is no solution. Moni, tell me some more about what's going on in your case. Okay. Stelissimo, thank you so much. Dogar Sam, I had my interview in 2019 and I still am waiting for my asylum results. Dogar, that is actually very, very common for persons who go through asylum. Asylum is like, I hate to say it, but asylum is not the sort of salvation that people think that it is, because when you file for asylum in the US, it is actually very complicated. It takes forever to just get an interview. And even when you get your interview, you may still not get a result right away. So there could be lots and lots of waits. If you have been waiting since 2019 after your interview, then you really need to speak to somebody about suing the government, because that is really, really bad. Lydia is saying, hello, I've had a 10-year green card, but my husband passed away. Next December will be 3 years of marriage. When can I apply for citizenship, please? From Lydia Lee. Lydia Lee, if you have a 10-year green card, I think you would need to wait 5 years since your husband has passed away, but it is worth doing an evaluation to see if you might qualify for the 3-year rule to citizenship, okay? Thank you so much for the follows. Why are current wait times so long for the marriage fee? From Ray94. Ray94, the wait times for USCIS applications are taking forever because, believe it or not, USCIS is nearly 4 million cases in backlog. 4 million cases in backlog. And here's a number, like, keep watching for my YouTube videos because I just dropped a great video about why cases are taking so long in immigration. There are almost 4 million cases in backlog and only about 12,000 immigration officers that are working. So believe it or not, that's actually one of the biggest reasons for the delay. Abdullah, hello, how are you? Nice to see you. All right, so let's go ahead and see what other, Junior Evaristorios, hello everybody. I have a felony charge. Can I put my citizenship to file? If you have a felony charge, if you have any sort of criminal history, it is super imperative and important that you get your criminal charges analyzed by a proper immigration attorney, not by a consultant, not by a notario. You need to get your criminal issues analyzed by an immigration attorney who is experienced in dealing with these matters, because even if you have your green card, if you have a criminal charge and you want to apply for your US citizenship, believe it or not, sometimes that criminal charge that gets explored and asked about during your citizenship process may actually even compromise your ability to keep your green card. And you may even lose your green card because of certain criminal charges when you apply for citizenship. So if you have any sort of criminal issue, before you apply for US citizenship, you still need to get this analyzed. And it doesn't matter if it happened 20 years ago or 5 years ago, you need to disclose it to your attorney. You need to get the documents and you need to get it analyzed, okay? So I wish you love and luck as well, all right? Mareti is saying, I have a pending I-485 and an I-130. My husband has moved out. We lost a child. We've been married for 2 years and a month. Please give me advice. Mareti, I'm really, really sorry to hear about that. Please accept my condolences about your child. I can't imagine how difficult it must be. And on top of that, you're basically your husband has left, right? So that's like a double pain, right? A double loss. So dealing with the loss of a child is difficult, right? And then if your spouse can't handle it, they leave, they blame it on you, you can't resolve it, and you're an immigrant waiting on your papers to be fixed through your spouse, then if you're number one at the bottom of the day, if your spouse walks out on you, if your spouse is a US citizen and they walk out on you, they abandon you, they leave the house, this can actually be, this is usually accompanied with other things. And spousal abandonment by itself is considered to be emotional abuse. Because let me explain it this way. If a couple is going through something and there's a disagreement or there's blame or there's fight, the normal thing to do, the healthy way to resolve that sort of a dispute is through communication, through talking, even if one person is upset or hurt, through normal communication where no gaslighting, there's no blaming, there's no screaming, no cursing, there's no sort of manipulative behavior like that. But if instead of resolving that difference, your spouse just ups and leave, that's terrible. And that is considered to be emotional abuse. And if you're in the middle of a green card case and your spouse up and leaves you and your case, then you should definitely speak to an attorney. You need to speak to an attorney. You need to speak to an attorney to explore whether filing for a VAWA self-petition is a right move for you so that you can save your case, take back control into your own hands, and try to move forward from this pain that you have going through, okay? Mareti, give us a call, please, 212-248-7907. And again, please accept my condolences about your child, okay? Nashi Posh, my first name on my green card is my last name and vice versa. I was looking to apply for naturalization online. Can you tell me how to put my name on it? It only asks for legal name from Nashi Posh. Nashi Posh, you may want to get your green card corrected to fix it, but sometimes when your green card has a name problem or a birthday problem or country birth problem, you really want to make sure that before you do anything that you have actually submitted the correct information to immigration in the first place. Sometimes you might submit something incorrectly and then the card gets produced and you just don't notice it until later. But sometimes it may be because your documentation has an error in it that can be bad for your case. So what I would recommend, Nashi, is for you to get your case evaluated by somebody who deals with correcting these mistakes. Because if you have to update your green card, you can update your green card. If it's the fault of the US government or your name was just written incorrectly on your passport and then it made its way over onto your green card, then one of the good things is that you may be able to update and change your name on your naturalization application, okay? But you definitely should talk to an attorney about this, okay? So Momen, I believe that you need to call us. We've given you certain explanations and I apologize for the time it's taken to prepare your case, but our objective is always to make sure your case is prepared well, okay? Do I need to renew my passport before applying for the I-751 from Elizabeth Anderson? Elizabeth, that is not usually a requirement that I've heard about, but I think as a immigrant in this country, you always want to have an updated passport anyway, okay? All right, let's go up to the top. Let's see. Danilo, what can I do if I applied for removal of conditions 14 months ago, but a year ago I discovered some affair from my wife? I try to work and move on, but I can't take it anymore. What can I do? From Danilo. Danilo, this is a common scenario. This is a common scenario where hello, Mrs. Cranon and Tamar Burton. So this is a common scenario. If you have a 2-year green card, right? You got your green card through marriage, you got your 2-year green card, and you're still in the marriage, you're still working it out, but then all of a sudden you discover that your husband or your wife is cheating on you. Now, here is the kicker. Here is the really scary part. This is why it's such a big deal. This is why an affair This is why you being cheated on by your spouse is not something that is small. Your spouse knows that you are relying on them for your green card. Your spouse knows that you have a little bit less of a say in the relationship in a way because of the fact that they're the US citizen. They know that you are waiting for them to sign the application to remove conditions or to show that you're still together. And of course, I'm not saying that every single person who cheats is doing it on purpose to hurt you. But when your spouse knows that something so precious as your future in the US, your ability to be free and safe from deportation, to not get detained, to not get denied, to not end up in immigration court, when they know that that isn't the balance, but they still want to do whatever they're going to do in regards to their extramarital affair. And then on top of that, they know that they know that they could withhold their help on your case if you get too angry or if you say anything to keep them in line or to tell them how upset you are. Then that is a classic abuse of power. That's a classic abuse of power. And I bet you that there are so many more things happening in your relationship. And when you're trying to keep it together, when you're trying to stay together, when you're trying to work things out and make your spouse happy no matter what, and they're still cheating on you, or they tell you that you're crazy, or they tell you that they could do whatever they want because they're a US citizen and that you only marry them for their green card, when they throw that back at you, that is not right. And if you have a 2-year residency card, then you should know that you can still file for your 10-year green card by yourself, and you basically ask for a waiver due to extreme cruelty and battery, because what we're talking about is not just normal cheating. We're talking about cheating accompanied by other signs of emotional abuse, okay? And if you don't have a green card at all and your spouse is a US citizen cheating on you and doing these things and blaming you and gaslighting you and telling you that they did it because you're not enough of a wife or you're not enough of a man, or that you should just be quiet and take it because who cares what you think, also not right. And if that's happening to you, then you may also qualify to file for a green card by yourself, okay? And if you want our assistance on your case, you can give us a call at 212-248-7907. All right, oops, lots of questions here. How long does it take till I get my green card after I got divorced after 3 years of marriage? I did a waiver from Patil. If you did a waiver due to extreme cruelty and battery, then you only need to wait 3 years. But if your waiver is due to divorce, then you've got to wait 5. Samantha, thank you for sharing my live. Will parents have to do a double perdón? From Mariela Covarrubias. Mariela, I'm not too sure what you're talking about in terms of the double perdón. Are you talking about the I-6, the 10-year bar? If you can explain a little bit more, I'd appreciate it so I can answer your question, okay? Oh, Mariela, I see your questions above. Okay, let me go back to the top. Hello, my sister will be turning 21 in February 2025. Will she be able to apply for my parents? She's a US citizen, but my parents had 3 kids in Mexico and they came over when they were little. So Mariela, without knowing more, if your parents came over through the border without inspection and your sister is turning 21, then your sister may not be able to assist your parents right away, okay? Because the number one key, if you are looking to get your papers fixed through your US citizen child, the first thing that the US government wants to look at is to see if you have a legal entry into the United States. And if you don't have a legal entry to the United States, then your life will become much harder as a result, because it's a penalty that they give. And if you have a 21-year-old US citizen child that wants to sponsor you, but you don't have a legal entry, here are the options that we can look at for you. Number one, we can look to see if your child has if they're in the military, either as a vet or in active duty. If that's the case and you don't have the permanent bar, then we could ask for something called military parole in place. Now, if your child is not in the military, or if you have the permanent bar because you left the US and you came back more than once without permission into the US, then we can look to see if you as a mom or dad of a US citizen, if you qualify for VAWA. or if you qualify for a T visa or a U visa. Now, these are the three best sorts of cases to do if you have the permanent bar, in my opinion. Of course, everybody has a different opinion, but if you have a US citizen child who is mistreating you, they're a rebellious child, they talk back to you, they curse you out, they throw fits, and they take advantage of you in different ways, then you may be able to qualify for something called VAWA self-petition, which can help you not just get protection against deportation, but in some instances, even if you have the permanent bar, we may be able to help you get a green card, okay? And many people are afraid to do this case because they think it's gonna harm their kids, but it does not. Now, if we cannot fix the permanent bar through VAWA because of one reason or another, then we can look to see if your parent qualifies for a T visa. The T visa is something that I like to call a miracle visa. I think that it is not used enough. I mean, many people don't know about what the T visa is. However, as immigrant workers in this country, many people have suffered through the things that would qualify them for a T visa. And the T visa is not just for parents, it's for any immigrant in the US that has suffered working conditions underneath a abusive or racist or cheating sort of boss that has really put them through a lot of things at work. And it's something that I really, really love to do for clients because it's very important that that you as a worker in the US who is my core belief is that it is hard enough to be undocumented in the US. And when you find out that your parents are being taken advantage of at work, they don't want to talk about work. I mean, here are some common signs that might give you clues that your parent might qualify for a T visa. Number one, if your parent never likes to talk about what they go through at work, but you can tell that they're having a hard time. You can tell that they're going through it. You can tell that they are kind of suffering a bit at work, right? Number two, if your parent is always at work, right? If you can see that they're working 10, 11, 12-hour days, they never take a sick day, they never take time off, and even if they're sick, they still insist on going to work, that can be a sign that something is not right at work, okay? Number three, if your parent frequently is without wages because the employer is not paying them on time or not paying them all of the money that they promised to pay them, that may also be a sign that your parent qualifies for a T visa. And lastly, if you have ever seen that your parent has gotten injured at work, they've gotten hurt, but then they're not really taking care of it and they're still insisting on going to work, and then maybe you even find out that they don't have proper safety equipment, that may also be a sign that your parent may qualify for a T visa. And again, I do want to emphasize that T visa is a pathway to US citizenship. It is a pathway to a green card. Once you get approved for a T visa, you wait 3 years before you apply for a green card. And then once you get your green card, then you wait the normal 5 years for US citizenship. Number two, you do not need a legal entry to file for a T visa. Number three, even if you have the permanent bar or a false claim to US citizenship, the T visa is still something that you can that can still help fix and waive and pardon all of those immigration problems. And lastly, you don't need any US relative to get a T visa, okay? 212-248-7907. Okay. I have my 2-year green card for a year and my wife and I divorced. Can I still get my 10-year card? From Joseph Ofusu. Yes, Joseph, if you have gotten your 2-year green card, but you and your spouse have gotten divorced, then you may be able to file for a divorce waiver, or depending on what happened in your marriage, you may also be able to apply for something called the extreme cruelty and battery waiver. Both are roads to applying for your 10-year green card by yourself. And you don't need your spouse's signature. You don't need your spouse's help. You don't need them at all, okay? So Joseph, you can give us a call, 212-248-7907. Now, I am really proud to say that in my office, we have handled hundreds of super complex I-751 cases. A lot of I-751 cases we have handled where let me just give you a rundown. Number one, client was already in deportation because the I-751 that their previous attorney filed for got denied, and then they ended up in deportation because the lawyer did not know how to ask for a waiver or did not ask strongly enough for a waiver. Number two, we have gotten I-751s approved for people who already got their I-751s denied underneath other lawyers, who just did not take the time to care about the case and to do the case properly. They got them denied. Guess what? They came to us and we still applied. And one thing that you should know is that if you have an I-751 in process, even if it gets denied, you can still file a second time. You don't have to give up. You don't have to go back home. You don't have to give up all of your life over here just because you had a bad and effective lawyer that did not care about your case, or because you had a spouse that did not want you to win. Number three, we have gotten I-751s approved for persons who had literally no evidence. One of the biggest things that you need in an I-751 case is joint marriage evidence, because the whole reason why the US government is asking you to file an I-751 is because they automatically think that your marriage is fake. And that's exactly why they give you only a 2-year green card, and they ask you to apply to remove the conditions, the bars, the holds upon that green card. And one of the ways that they measure to see if your marriage was in fact real is to see how much evidence you have. So if you don't have a lot of evidence, that is actually one of the most common reasons why people's I-751s get denied. But believe it or not, one of the top reasons why people do not have a lot of evidence or any evidence from their marriage for their I-751 case is because their spouse was controlling everything, because the spouse did not want to put names on documents, did not want to share information, did not want to give them anything, and in the end did not want to file with them, right? So when that happens to you, I want you to understand that those things are actually signs of emotional abuse, because there are ways that your spouse is still controlling your case. They're still controlling your life. And if that has happened to you, even if your I-751 got denied, or if you failed, if you did not file your I-751 and your card is expired, it is not too late. I have literally taken cases out from the grave, okay? I have a case that got approved earlier this year where the client got their I-751 denied, got sent to immigration court. The judge then ordered them removed and denied their I-751 in court and ordered my client removed. Client came to me 10 years after the fact, filed a motion to reopen in court, filed a new I-751, got the case in court dismissed, and we got the I-751 approved, and we finally got my client his 10-year green card that he deserved to have gotten 10 years ago, except his lawyer did not care enough about his case, okay? Rant over 212-248-7907. All right, let's see some questions that we have. Do you think that the eligibility requirements will change for the T visa if Trump is elected? From KK, no, I don't think that they're going to change. But I do think that we might get more requests for evidence. It might get, it'll get probably maybe a little bit more challenging, but not impossible to improve, just like it was before. Let's see. Pablo, my dad has a cocaine felony charge. Could he ever try to start a status from Pablo? Pablo Jr., I'm so sorry to hear that your dad has a cocaine felony charge. Now, drug charges are the most difficult thing to deal with in immigration. And if you have any sort of serious drug charge and you're undocumented and you're looking to get your green card, or you already have a green card and you get a really serious charge, especially for that type of a drug, there's usually no way to fix it, okay? And what I would recommend to people instead is to revisit the court where the criminal conviction was issued, and to try to seek out help to basically reopen that case, because 9 times out of 10, if you're an undocumented immigrant, you get arrested for something and you take a plea, 9 times out of 10, the defense attorney that you have, even if you hire a private defense attorney, criminal defense attorney, or if you get the public legal aid attorney, 9 times out of 10, you may not be advised properly about the immigration consequences of that criminal conviction. And what that will do is that will cause you unknowingly to agree to a plea deal that has a serious immigration consequence, such as in your father's case, Pablo. And the only way to do that is to go back to that court and challenge that court through something called a Padilla motion, to basically reopen that conviction and to let the court know that you were improperly advised about the immigration consequences of that conviction. And you're basically asking the court to vacate it, to erase it, to put you back onto ground zero so that you can try that case again and get a proper conviction that does not prevent you from immigration options. So the bottom line is that drug convictions are no good. They're no bueno, no mas. Okay, they're no bueno in immigration. But if you do happen to have any drug conviction that is anything more or different than 30 grams of marijuana possession, you need to speak to like a criminal attorney, and probably your best defense might be to go back to the criminal court to get that vacated. Okay. I want to get my citizenship. I want to first divorce my husband, then I want to apply from Saba Ali. Saba Ali, you could do that, but sometimes you may not need to. Sometimes you may be able to do a waiver on your own. I filed VAWA in December 23. I have not received my EAD, only prima facie and advance parole. Must I worry from Macy? Macy, yeah, that's quite a long time. I think you should do some inquiries with the Vermont Service Center to see what's going on, and you might want to double check to see if the EAD application was actually filed. Okay. Entered in 2000. I don't have a FOIA. How can I adjust my mom that's been living here? She entered legally. From Fatima. Fatima, I'm assuming that you have a citizenship. Oh, somebody says I look like Kamala Harris. Oh, that's nice. Thank you for that compliment. I don't mind looking like the future president. Can you file for a green card through VAWA even if you have the permanent bar from FISH? FISH, absolutely. Even if you have the permanent bar, you can still file for a green card through VAWA. However, there is one condition. We have to be able to show how the mistreatment and abuse that you suffered from your relative is somehow connected to you leaving the US or coming back. And I say that everybody should try. Everybody should try. You never know what's going to work. You never know when they're going to approve you. And even if you think, if somebody tells you that, oh, it's a weak connection, still file it. You've got nothing to lose because the application is free anyway. Okay. So let's see what other questions I have. Pablo Kamala, I moved my case near me to an immigration court 8 months ago, but till now the court doesn't notify me yet. What can I do from Pablo? Pablo, if you're in immigration court and you're waiting to find out about your notice, your interview notice, I think the best thing to do is to try to just keep checking once a month, the minimum, bare minimum, check once a month online or by calling the hotline. It's like 1-800-898-7180. I think that's the number for EOIR. Put in your A number to see about any upcoming hearing dates, okay? I do not file EB1 or EB2 or EB3 or EB4 or EB5. Nothing EB. Oh, Chelsea, thank you. I couldn't sleep before I met you, and I have all the burden lifted off my shoulders. You and your team are super incredible. God bless you. Patience. Thank you so much. Patience. It's been our pleasure to serve you. Ashwani, hello. Nice to see you. If divorce is happening with the U.S. citizen still eligible to T visa, yes, absolutely, Ashwani. Divorce does not affect. The only time that divorce actually affects anything in an immigration case is if it's based off of marriage. So if you're filing a regular case with your spouse and you guys get divorced, then you can't do it. But if you're filing for VAWA and you get divorced, then you have a deadline of 2 years. If your spouse dies, you have a deadline of 2 years to file. Divorce also does not affect anything like the T visa. Emmanuel, is it okay for a 19-year-old to marry a 19-year-old and file for him? Emmanuel, yes, I believe you're already 18, above 18, so you should be okay. and you should be able to do the I-864. What is the difference between order of removal and deportation proceedings? Deportation proceedings is basically a removal proceeding, and you get an order of removal at the end if the judge decides that you have not proven a defense to staying here, okay? So it's kind of like the order is the thing that you get at the end. It shows the conclusion of the case, okay? If you get a green card through VAWA, can you join the U.S. military? Is it automatically that I'll be a U.S. citizen? From Andres Campbell. Andres Campbell, great question. If you get a green card through VAWA, you still have, nobody ever becomes a U.S. citizen automatically after getting a green card unless you're under 16 when you get your green card through a U.S. citizen parent. That's a little bit different, but if you're an adult who gets a green card through any sort of case, if you get a green card through VAWA, then you have to wait 3 years before you apply for U.S. citizenship. The majority of everybody else has to wait 5 years for U.S. citizenship, okay? All right, guys, that's all the time that I have for today. Please write my phone number down, 212-248-7907. Please, I have a favor to ask of you. If you find my content useful, if my videos have helped you out, or if you think that they can help out somebody that you care about, please share them with that person, because you never know when what I say and what I share is going to help change their lives. Knowledge is power, and as immigrants, we do have to do what we can to share this sort of knowledge, okay? I hope everybody has a wonderful day. Oh, I did say that, okay, I was going to discuss a question about whether your spouse is secretly sabotaging your green card case. So let's talk about this before I end. Is your U.S. citizen spouse secretly sabotaging your case? And what are the signs? Well, I'll tell you right now that the number one sign that I see of a U.S. citizen spouse trying to sabotage their spouse's case is not giving the documents, not giving the tax return. The tax return is a big excuse that U.S. citizens give, or green card holders give, when they don't really want to really help their spouse get a green card. So if your spouse refuses to give you their information, or refuses to give you the things that the lawyer asked for, and usually what I see is that it's the tax return. And I'm not talking about doing a joint tax return. I'm talking about just simply giving you the tax documents. If your spouse simply refuses to give the tax documents or anything else, that's one sign that they may be trying to sabotage your case. Number two, if they completely fail to show up to the interview, or they tell you that they're not going to show, or they show up late, or they don't want to practice, or they don't want to go to the attorney's office for the preparation, that's a good sign that they're trying to sabotage your case. Number three, if they start answering things wrong at the interview. If you guys have an interview for your green card and your spouse all of a sudden seems to forget everything or get everything wrong, and you know they know the answer, it's a good sign that they're trying to sabotage your case. And if they are trying to sabotage your case, or if they have already sabotaged your case and your case got denied, don't give up. You may still be able to do a valid self-petition. And we would love to evaluate your case to see if you may qualify. Our telephone number is 212-248-7907. We do have a fee of $150, which we're happy to give back to you if things don't work out with us, okay? So call us 212-248-7907. I hope you guys have a wonderful night. Thank you, and God bless.